Welcome to today's deep dive. Our mission today is to unpack a really fascinating, highly complex, and honestly intensely controversial legislative proposal.
Yeah, it's the big one.
It really is. So we're looking at the Citizenship Act of 2026. That's officially H.R. 9854, which was introduced by Representative Brandon Gill in the House and Senator Jim Banks in the Senate. And we're basically basing this whole analysis on a really detailed recent breakdown by legal commentator Robert Gouveia.
Right, and we're going to, really look strictly under the hood of the legal machinery here. Because to do that, we have to examine the architecture of a bill that's, well, designed to do something pretty unprecedented.
Yeah, but before we go any further, I actually need to address you, the listener, directly for a second.
Definitely.
Because the source material we're diving into today contains incredibly strong rhetoric, right? Politically charged content, very partisan viewpoints on immigration. And the goal of this deep dive is strictly impartial.
Completely neutral.
Exactly. We are not endorsing or validating or really taking sides on any of the claims made in the source material. We're just, breaking down the legal arguments, the tactics, and the historical precedents exactly as they're presented, just so you can understand a major political development.
Yeah, and understanding those mechanics is key because the central puzzle of this legislation is how it attempts to end birthright citizenship without actually amending the 14th Amendment.
Which is wild. And that brings us to the core strategy. I mean, imagine you're playing a high-stakes board game, right?
Yeah.
And you are just completely losing under the current rules.
Right.
Every single time you try to argue with the referee about what those rules actually mean, you get shot down. So instead of, continuing to argue about the rules you're losing on, you just flip to a completely different, almost forgotten section of the rule book. You point to a technicality and you just say, actually, we're playing by these rules now.
That is exactly what they're doing. Because, the 14th Amendment has been the absolute center of gravity for every debate on birthright citizenship for well over a century.
Right.
Specifically, it's that phrase, subject to the jurisdiction thereof. Lawmakers have literally spent decades trying to argue that undocumented immigrants are not subject to U.S. jurisdiction.
But they hit a wall.
The massive gridlock, yeah. So the authors in the Citizenship Act of 2026, they looked at that endless gridlock and decided to just completely bypass it. They're pointing to Article 4 and Article 1 of the original Constitution instead.
Okay, so let's unpack the mechanics of that pivot because it's fascinating. So Article 1 gives Congress the authority to establish uniform rules of naturalization. Which, okay, that makes sense. But Article 4 is the real engine here, right? I mean, it's part of the foundational Constitution. It was drafted decades before the 14th Amendment even existed, and it basically guarantees that the federal government will protect the states against invasion.
Yes. And the entire legislative strategy hinges on that single word, invasion.
Invasion.
Right. So the bill officially codifies an executive order dated January 20th, 2025. And that order actually declares that the mass unlawful movement of people into the United States is not migration. It is an invasion.
Okay, so I understand the political messaging there, obviously. But how does labeling it an invasion legally connect to birthright citizenship? Because usually when we think of an invasion, we think of foreign militaries, tanks, that sort of thing.
Okay.
And citizenship is a totally separate, civilian administrative issue.
Well, to bridge that gap, the proponents of the bill rely on a very specific historical exception. So under long-standing British common law, if a hostile foreign army occupies your territory, and one of those occupying soldiers has a child on your soil, that child does not automatically become a citizen of your country.
Oh, because they owe their allegiance to the hostile sovereign, not the host nation.
Exactly.
I mean, that makes intuitive sense for an actual literal war.
Right. And that identical logic was reaffirmed in the United States way back in 1898. There was this really landmark Supreme Court case called Wong Kim Ark.
Oh, right. I've heard of that one.
Yeah, so the court actually ruled in favor of birthright citizenship for the child of Chinese laborers in that case. But in doing so, the justices explicitly laid out the exceptions to the rule.
Meaning they clarified who doesn't get it.
Exactly. They acknowledge that children born within territory under hostile occupation by a foreign force are an exception. They are not entitled to birthright citizenship.
Okay, wait, I want to pause here for a second. Because the source material mentions this whole new bill is a direct response to a Supreme Court decision referred to as Trump v. Barbara.
Yeah.
And I am admittedly completely in the dark on the specifics of that case. So why did that specific ruling force lawmakers to pivot all the way back to this 1898 exception?
So the source basically frames the Trump v. Barber decision as a massive setback for the proponents of this bill. They describe it as a disaster for American sovereignty.
Wow.
Because essentially, that ruling completely shut the door on their preferred interpretation of the 14th Amendment. The court just didn't buy the argument that conventional illegal immigration somehow nullified birthright citizenship under that subject to the jurisdiction clause.
Okay, so the door on the 14th Amendment was slammed shut.
Exactly. However, the majority in that case did acknowledge that the historical invader exception still exists in American jurisprudence.
Ah, so it's like a legislative judo move.
Exactly that.
They're taking a Supreme Court laws, finding the one single loophole the justices acknowledged, and driving a massive legislative truck right through it. They're basically saying, fine, we won't touch the 14th Amendment. We're just going to redefine who qualifies as an invader under Article 4 and apply that historical exception you just said exists.
Yeah, the strategy completely shifts the legal battlefield. The challenge, of course, is that to make this actually work, you have to formally categorize modern, civilian, undocumented immigrants under an 1898 legal exception that was meant for hostile occupying armies.
Right. And here is where it gets incredibly expansive. And honestly, where I kind of have to push back a little on the mechanics of this.
Sure.
Because traditionally, an invading force involves people with weapons, flying a foreign flag, actively trying to overthrow the government. But looking at the text of this bill, the definition of an invader is remarkably broad.
It is extremely broad. The text explicitly defines an invader as anyone who has not been lawfully admitted to the United States, as well as anyone who is otherwise unlawfully present.
Unlawfully present. So that means if you came here legally, say on a tourist visa from the UK or a student visa from India, and you overstay that visa by a single day, under this legislative definition, you are legally designated as an invader. You are placed in the exact same legal bucket as a hostile foreign soldier.
The legislative net is designed to catch absolutely everyone outside of lawful permanent residence. The authors intentionally leave no room for administrative nuance whatsoever.
Wow.
And they actually go even further by explicitly targeting what they call birth tourism. Right. The bill designates anyone who enters the country, even legally, with a completely valid visa, whose sole purpose is deemed by a consular officer to be giving birth in the U.S. as an invader.
And the source material focuses heavily on commercial surrogacy to justify this part, right? Like Senator Jim Banks cites this anecdote about a Chinese billionaire who allegedly fathered over 100 U.S. citizen children entirely through commercial surrogacy in the United States.
Yeah, and the scale they present in the source is staggering. They claim there are over 1,000 Chinese birth tourism companies operating right now.
1,000?
Yeah, and they estimate that 1.5 million nationals of the People's Republic of China have acquired U.S. citizenship through these methods. And the underlying argument they make suggests that this is actively enabled by the Chinese Communist Party.
Which changes the framing entirely.
Right. Consequently, the bill specifically designates any national of a covered nation who enters into a commercial surrogacy contract solely to have a child in the U.S. as an invader.
Mechanically, though, how does a consulate officer even prove that a legal visitor's sole purpose is to give birth? I mean, that seems incredibly difficult to actually enforce.
Very difficult.
But, beyond the enforcement, I have a big question about the timeline. The source mentions the bill operates both retroactively and prospectively.
Yes, it does.
So let's say I'm someone who overstayed my visa 5 years ago. Am I suddenly classified as an invader today?
Yes. The bill instructs that the phrases not lawfully admitted and not lawfully present apply to all persons, regardless of when they entered. So the parent's status as an invader is fully retroactive.
Okay.
The moment the bill is signed, that legal label applies to anyone currently in the country without lawful status.
Wait, hold on. Does that mean a teenager who has lived here their whole life, who was born to undocumented parents, suddenly loses their U.S. citizenship?
No. The revocation of citizenship itself is entirely prospective.
Okay, that's a huge distinction.
Right, so if you're currently here illegally and you had a child on U.S. soil last year, that child remains a U.S. citizen. The bill only targets children born after the date of enactment.
Got it.
So moving forward, if a person designated as an invader has a child, that new child will be excluded from birthright citizenship.
Okay, phew. That clarifies the timeline. But let's look at the causal link here again. To completely redefine a civilian visa overstay or, a mother seeking better economic conditions as a literal invader, that requires an earth-shattering justification.
It absolutely does.
You can't just slap a military label on an administrative infraction without convincing the public and the legal system that this is a literal threat to national survival.
And that is exactly what the proponents are doing. To unlock Article 4's protection from invasion clause, they cannot frame migration as an administrative border issue or a humanitarian crisis or a labor market dynamic.
Right.
They are structurally required to frame it as a coordinated, hostile threat to national sovereignty.
So the source outlines several major pillars for this justification, starting with just sheer demographics, right? Like, they cite that under the current administration, temporary programs and parole apps were used to facilitate mass entry, resulting in an estimated 15 million illegal aliens currently in the U.S.
Yes.
And they emphasize that nearly 16% of the total U.S. population is now foreign-born.
Right. And proponents argue this creates severe downstream consequences. They point to increased housing costs, depressed wages, and public safety threats, specifically citing the entry of cartel members and foreign operatives.
Right, but it's not just economics.
No, the crux of the justification goes far beyond economics. The source introduces this concept of the global weaponization of migration.
Okay, so what does that actually mean for you, the listener? I mean, if you're listening to this on your commute, just going about your daily life, how does this framing shift your reality? How does viewing migration through this specific lens completely alter the conversation?
Well, it fundamentally changes how the nation defines its local communities and its security. If you adopt this framing, the demographic shifts happening in your city or, your child's school, they're no longer seen as the natural byproduct of a globalized economy or people seeking a better life.
They're recast entirely.
Exactly. They're recast as acts of asymmetric warfare. It turns what was a civilian issue into a geopolitical conflict playing out right in your neighborhood.
And the source dives into a concept called the Reconquista to solidify this hostile narrative, right?
Yes.
This is basically the idea that migrants from Mexico aren't just moving north for jobs, but are actively, deliberately trying to reclaim territories like Arizona, New Mexico, Texas, and California, the land that was ceded to the U.S. in the 19th century under the Treaty of Guadalupe Hidalgo.
That's the argument. The material claims that certain foreign politicians openly refer to U.S. cities as occupied territories or migrant land. And by taking those statements and framing the movement of people as a deliberate attempt to reclaim ancestral land, it perfectly fits the narrative of a hostile invading force. It attempts to legally establish that this is not migration. It is a slow-motion demographic conquest.
Which perfectly brings us back to the election fraud angle, which is tied directly to that birth tourism issue we talked about. Because if you're viewing this purely as asymmetric warfare, creating citizens via surrogacy is seen as manufacturing future political operatives.
Exactly. Senator Banks poses a very specific hypothetical in the source material. He says, imagine if there are over 1 million U.S. citizens who were born via surrogacy or birth tourism, but who spend their entire lives raised in China.
Right.
Under the influence of a rival government. They still retain the constitutional right to vote in our elections.
So the fear outlined there is that foreign adversaries could theoretically have 1 million absentee ballots sent overseas, fill them out, and use them to completely flip the results in crucial swing states without ever firing a single shot.
Yes. And this rhetoric, it is the necessary load-bearing pillar for the entire bill. Without framing these scenarios as an existential, coordinated attack on the Republic, the word invasion falls apart completely.
And with it, the constitutional authority to bypass the 14th Amendment.
Exactly.
Okay, but I have to stop and challenge a massive contradiction here, because they are using the word invasion. They are talking about demographic attacks, hostile territorial takeovers, foreign adversaries rigging elections. It sounds exactly like a declaration of war.
It really does.
Yet, the bill explicitly includes a clause stating that absolutely nothing in the act authorizes the use of military force or invokes the War Powers Act.
Right.
How can you have a hostile invasion that doesn't trigger a military response?
Well, the authors are walking an incredibly delicate legal tightrope here. Because if they invoke the War Powers Act, they trigger a massive, uncontrollable cascade of international law, military oversight, Geneva Convention obligations, and severe limitations on the executive branch.
Oh, that makes sense.
Right. They do not want the military deployed into civilian neighborhoods to enforce immigration law.
So they want the legal cheat code without the operational nightmare.
Precisely. They need the legal definition of invasion strictly to unlock Article 4 and rewrite the citizenship rules. But They want to keep the enforcement of that invasion strictly within the bounds of domestic civil and criminal law. So, things like ICE raids, deportations, and Border Patrol operations.
It's like calling a localized fire a Category 5 hurricane, purely so you can unlock federal hurricane relief funds, but then strictly forbidding the meteorologists from tracking it like a storm.
That's a great way to put it.
Which actually brings us to the final and perhaps most aggressive part of this entire legislative strategy, the legal shield.
Right. Because the authors of this bill are well aware that passing a law redefining millions of civilians as invaders will result in an avalanche of immediate, fierce legal challenges from civil rights groups, states, constitutional scholars, everyone.
It would be tied up in court for years.
Exactly. So to counter that, they built a defense mechanism directly into the text of the bill to lock the courts out of the process entirely.
It's essentially putting a force field around the legislation. You're telling the referees, the federal judges, that they aren't allowed to blow the whistle or even review the instant replay on this specific play.
Right.
But how do you legally tell a judge they aren't allowed to judge?
You utilize a doctrine known as the non-justiciable political question. The bill explicitly categorizes the declaration of an invasion under this specific doctrine.
Okay, that is some incredibly dense legalese. What does a non-justiciable political question actually mean in practice?
So in constitutional law, there are certain issues that are so fundamentally tied to the political branches of government, meaning the executive or the legislative branches, that the courts decide that they just lack the jurisdiction or the tools to rule on them.
Okay.
The source references historical precedent, specifically a case involving California and Governor Abbott, to argue that determining whether an invasion exists lacks a judicially discoverable and manageable standard.
Meaning the courts literally do not have a constitutional rubric or like a measuring stick to look at a border crisis and objectively score whether it is an invasion or not.
Exactly the argument. The courts have historically thrown their hands up and said, we cannot define what an influx of migrants means for national security. That is for the politicians to decide.
Oh, wow.
Yeah, so the bill weaponizes this exact judicial hesitation. If Congress passes this law declaring it an invasion and the president signs it, a federal judge cannot step in, open a dictionary, and say, well, this doesn't look like an invasion to me.
So the bill attempts to completely strip the judicial branch of the power to review or overturn the invasion designation?
Yes.
The source puts it very bluntly. If you, as a citizen, do not like the decision that it's an invasion, your remedy is to run for Congress and change the law. Your remedy is not to sue in federal court.
And to fortify this force field even further, the drafters included a severability clause.
Now, a severability clause is fairly standard in legislation, but applied here, it's incredibly tactical. I mean, it's like a lizard dropping its tail to escape a predator, right? The main body just keeps running.
That is the perfect analogy. The severability clause dictates that if the Supreme Court does somehow pierce the force field and finds a way to strike down one specific section, for example, if they rule that designating commercial surrogacy as an invasion goes too far and violates other rights.
Which seems plausible.
Right. But that ruling does not invalidate the rest of the act. The courts can chop off the surrogacy tail, but the visa overstay provisions and that core Article 4 pivot remain fully intact and operational.
And the source material calls this tactic brilliant because it gives the legislation maximum survivability in a really hostile legal environment.
Absolutely. By tying the court's hands on the definition of an invasion, the bill's authors deliberately move the battlefield. They force any Supreme Court challenge to argue about abstract jurisdictional boundaries and the original articles of the Constitution, rather than allowing the courts to get bogged down in the messy, heavily litigated weeds of 14th Amendment civil rights law.
It really all comes back to that board game analogy we started with. The proponents of this bill realized the 14th Amendment game was a permanent gridlock. So they found a way to use Article 4, combined with a highly aggressive interpretation of the word invader, to just rewrite the rules entirely.
Yeah, if we summarize the journey of this deep dive, we've explored how the proposed Citizenship Act of 2026 attempts a breathtaking constitutional end run. It completely sidesteps the 14th Amendment by activating Article 4's guarantee of protection from invasion.
Right.
It radically reclassifies undocumented immigrants, visa overstays, and birth tourists as invaders, based on an 1898 legal precedent meant for hostile armies.
And it builds the foundation for that reclassification, using intense rhetoric, framing migration as a demographic attack, a reconquista, and a massive national security crisis.
Exactly.
And finally, it attempts to legally shield this entire mechanism from the judicial branch by declaring the definition of an invasion a non-justiciable political question.
It is, frankly, a masterclass in legislative engineering, regardless of where anyone stands on the politics of the issue. The sheer audacity of the legal architecture is remarkable.
Which leaves us with a much larger, frankly staggering philosophical question to mull over as we wrap up today.
Right. What is the broader implication here for you?
Well, think about it. If Congress can unilaterally take a totally non-military event like overstaying a tourist visa or hiring a commercial surrogate and legally define it as a literal invasion, and if they can successfully shield that new definition from ever being reviewed or overturned by the courts, what other foundational constitutional rights could theoretically be altered in the future simply by changing the definition of a single word in the rulebook?
A precedent like that cuts to the very nature of how reality is defined within our legal system. It suggests that our constitutional rights are only as secure as the definitions of the words used to grant them.
It really does. Thank you so much for joining us on this deep dive. We hope this breakdown helped you understand the complex legal machinery operating beneath the headlines. Keep questioning the rulebook, and we'll see you next time.